that we don't intend to renew this evening. So in the event of a fire or an alarm, make your way to either end of the ballroom and follow the instructions of the DFA staff. Today's event is also being live streamed, so please put your phones on silent. If you'd like to tweet, you can do so with the hashtag EU50 and hashtag St. Brigid's Day. And finally, should you need to leave the room at any time, please do so discreetly. Minister, Presidents, Attorney General, Chief Justice, Ambassadors, friends from Ireland, Strasbourg and across the world. We're delighted you're able to join us this evening. This is the second Iveagh House lecture in a special EU50 series for Ireland's 50-year membership of the EU. It was launched last autumn with a fascinating presentation by Michel Barnier. Our keynote lecturer tonight also has a French connection, having served in Strasbourg for almost a decade now. But of course, Judge Síofra O'Leary is a native of this city. And unlike Monsieur Barnier's commission, the institution over which she presides, the European Court of Human Rights is, as we know, not part of the EU, but the Council of Europe. The Council of Europe is far larger in membership and older in years than the EU, indeed one which first flew the flag behind me and sang Ode to Joy before the EU adopted it. Today marks Judge O'Leary's first official visit to Ireland since her election late last year as the first Irish person and first woman to lead the European Court of Human Rights. And alongside EU50, we're also celebrating St. Brigid's Day and the achievements of Irish women across the world. So following President O'Leary's keynote remarks, I'm delighted we'll be joined on stage by two other remarkable Irish leaders, Senator Fiona O'Loughlin and Professor Aoife Nolan, who was herself elected President of the European Committee on Social Rights only last week. And after their reflections, we'll end our evening with a performance by acclaimed harpist and sean-nós singer Sheila Denver and fiddle player Valerie Casey. Now, to set the scene in greater depth and to introduce President O'Leary, I'll shortly invite our host, Ireland's newly appointed Minister for European Affairs and Defence, Peter Burke, to take the stage. But before we hear from the Minister, a very short film which the Department of Foreign Affairs has put together this year to capture part of what St. Brigid's Day means. Is Misha Brigid, I am Brigid.
Brigid, Brigid, was born long ago, and just yesterday. Her day is the start of spring and the end of darkness. She crafts. She weaves. She heals. And her words are poems. She is compassion, charity, and pride. And even used a cloak to build an empire. Its threads binding sister to sister. She is me, and she is you. She is a multitude. I am Brigid. I am Brigid.
I am Brigid. I am Brigid. I am Brigid.
I am Brigid.
It's Misha Brigid.
It's Misha.
Gurv Mahagut, Fiona, President O'Leary, Chief Justice O'Donnell, Attorney General, Justices, Ambassadors, members of the Oireachtas, friends. Fáilte go teach Iveagh. Welcome to Iveagh House. Agus Banachti na Féile Bríd Ormh go léir. And happy St. Brigid's Day to you all. Firstly, I just want to mention, unfortunately, as we live in a democracy, I have to leave after my contribution because we have votes over in the Dáil just beside us here. You might not credit it, but February 1st marks the opening of spring in Ireland. Indeed, folk legend has it that St. Brigid herself promised every second day fine from my day onward and half of my own day. Now, some might say that to deliver an Irish spring where half the days are fine would in itself be a miracle worthy of benediction. But the significance of the shifting seasons, the promise of new light after the dark winter, is very real, reflected in the image of that sacred flame which, by legend, Brigid kindled in Kildare 1,500 years ago. Alongside Columkill and Patrick, Brigid is one of Ireland's 3 patron saints. Her day and the Celtic festival of Iveagh, which preceded it, has been celebrated for millennia. But this year is the first it has been marked with a public holiday. Not before time. But why now? In part to recognise the long COVID winter we've all endured these past few years and remember those we lost through it. But more than that, to celebrate. Brigid's name can be translated as the Exalted One, and increasingly her festival has come to be an exaltation of Irish women here in Ireland through civil society and community initiative. A nationwide programme has blossomed. While abroad from Washington to Warsaw, Sydney to San Diego, our diplomatic network have come to host a series of events each February 1st to match our efforts on March 17th, celebrating the remarkable contribution Irish women have made and continue to make across the world. This evening's programme is, in part, such a celebration, but a very particular one. For over a decade, the Department of Foreign Affairs has hosted a series of special lectures here at Iveagh House, inviting distinguished speakers to consider seminal events in our state's history. This ballroom has echoed with the insights of prime ministers and presidents, the reflections of secretaries generals of the world's leading multilateral bodies, the wisdom of some of the century's great civil rights activists. Within that tradition, these past months, we have launched a new series of Iveagh House lectures, devoted to deliberating on how over half a century of membership of the European Union has shaped Ireland, and how Ireland, in turn, has shaped the European Union. But EU50 is about more than simply EU membership. It is about the values the Union represents and from which it was built. We understand this well, because a quarter of a century before Ireland joined the European Union, we lived and shaped these same European values. In London in 1949, before the Coal and Steel Pact was ever forged, Ireland was amongst the 10 original signatories to the statute that created the Council of Europe, a community of states headquartered in Strasbourg, dedicated to the protection of democracy, human rights, and the rule of law. Independent of the EU, but working always in partnership with it. For almost 3/4 of a century, the Council, above all, through the European Court of Human Rights, has served as the conscience of Europe. Now comprising of 46 states, it continues to protect the rights of 700 million European citizens, not through examples of power, but through the power of example. Last year, Ireland had the privilege of chairing the EU Council Committee of Ministers for the 7th time. In the wake of the Russian invasion of Ukraine and subsequent expulsion from the Council, our 6-month presidency launched a process of institutional renewal, which will culminate this May when the Council convenes just its 4th summit in the history in Reykjavik. A cohort of remarkable Irish women drove this effort. In the 1980s, our former president, Mary Robinson's advocacy before the Strasbourg court changed this nation's history. Last year, she led a wise persons group in identifying recommendations to shape the Council's future. Complementing her work, the Council's Parliamentary Assembly last week agreed its own detailed recommendations for reform. These were penned by the leader of our Oireachtas delegation to Strasbourg, Senator Fiona O'Loughlin, like Brigid, a proud Kildare woman, and indeed chair of the Oireachtas Women's Caucus. The O'Loughlin and Robinson reports, if I might call them that, are blueprints for institutional renewal. They drew on the expertise of Strasbourg's leading minds, and we have several of those with us this evening. Just last week, Professor Aoife Nolan was elected President of the Council's European Committee on Social Rights, on which she has served with great distinction for several years. Cogordagus Acree Aoife. And with her, our honoured lecturer, Judge Síofra O'Leary. Her election as President of the European Court of Human Rights last September was a reflection of her excellence as a judge and the esteem in which she is held by her peers, factors independent of her nationality or her gender. But in the final weeks of our presidency term, it was a source of special pride that the first female president of the court should be Irish. In my previous role in the Department of Housing, I brought in maternity leave for local councillors for the first time and allocated additional funding to political parties and civic groups. This funding was tied to commitments from these groups to support gender balance on election tickets in the run-up to the local elections in 2024. Young girls and women need role models, not just in politics, but in all walks of life. And in the legal and humanitarian sphere, there can be no higher profile position than President of the European Court of Human Rights. The Court is at the very core of the Council of Europe, the moral compass by which states must steer in delivering commitments under the Convention. The implementation of its judgments is simply a legal requirement. It's a moral imperative. That's why, as Presidency, Ireland treated so seriously states' failings to implement court judgments. It is why, as part of a package of over €2 million in voluntary contributions to the Council last year, we focused on funding implementation of court rulings. And why, working with colleagues across the Council, we'll ensure that reinforcing the court is amongst the first priorities of the Icelandic Summit. Let me mention two other subjects on which our leaders will reflect in Reykjavik. First, countering violence against women, which was a particular priority for our Council presidency, and is the focus of the Council's Grevio committee, which visits Ireland this week. On that, let me recognise the presence here of Professor Eileen O'Malley Dunlop, who was elected to Grevio last year. Congratulations, Ellen. And thank her and her colleagues for their extraordinary efforts and to promote and monitor implementation of the Istanbul Convention. Last summer, amidst all the challenges they face, Ukraine's parliamentarians ratified that convention, reaffirming yet again Kiev's commitment to core democratic values. So amongst the many diplomats here tonight, a special welcome to Ambassador Jarasko, a brilliant diplomat whose own courage and resilience reflects that of the tens of thousands of our fellow Ukrainian women and girls who found refuge in Ireland over the past year. Ambassador Jarasko, as I know, you will join me tonight in thinking of your Irish counterpart in Kiev, Therese Healy, one of the most brave female diplomats who now lead over half of our diplomatic missions worldwide. Ireland is unfortunate indeed to be so well represented overseas. And I wish Therese and all the outstanding women driving our department, and especially a happy and safe St. Brigid's Day. This being Brigid's Day, and more importantly, Shafia's evening, I thank you and know you spent long enough listening to a male minister. But a final word before I invite President O'Leary to take the plinth. Before it became home to the Department of Foreign Affairs, Ivy House was home to the Guinness family. And as Fiona will know, Arthur Guinness was, although revered in Dublin, was born in Kildare. But that's not the only thing that he shares with Brigid. For Brigid too was a brewer. Amongst the many miracles attributed to her, perhaps the greatest was to transform bathwater into beer. Now, justices, ambassadors, I promise you tonight's refreshments were aged in barrels, not baths. But I hope you'll all join me in toasting our speakers, in congratulating the remarkable women leading the Council of Europe in Strasbourg, and in wishing all the women of Ireland and all those representing Ireland, wherever they may be, a brilliant St. Brigid's Day. Sláinte. President O'Leary, the floor is now yours.
Minister, distinguished panelists, ladies and gentlemen. My thanks go to the Minister for organising this event and for your very kind introduction. It's a pleasure, as always, to be in Dublin because I get to see so many familiar faces and friends. And in addition, your invitation allows me in a few hours to cast aside the role of judge and instead be with my children, who are rerouting in the country their mother left over almost 34 years ago. I'm conscious of the brilliant women who are assembled for the panel discussion and of my limited time, so I will crack on. When I was asked to address you on St. Brigid's Day as part of the EU50 series, I was given a fairly blank canvas, but reference was made to women's rights given the day that's in it. I hope you'll forgive me, but I decided to cast my net a little wider, looking at the rights conferred by European law on different groups within our society, as I think that it's more illustrative of the impact of the European Convention on Human Rights in this state. We gather to celebrate 50 years of Ireland's accession to the EU, but 2023 also marks 70 years since Ireland ratified the Convention, it being one of the first two states, along with Denmark, to do so. In the time available, I'd like to give you a taste of the role Ireland has travelled since its ratification of the Convention, turning towards the end of my speech to a subject which demonstrates one of the many roads which still remains to be travelled. It's already been referenced by the Minister, and which points to the Convention's enduring value. In a recent speech in DCU in October last, I referred to Ireland's European journey from isolation to integration. This journey was undertaken in two European fora, the Council of Europe and the EU. And it's a journey which has seen our country undergo transformation upon transformation, driven or drawn by a great many forces and factors. My focus naturally is on legal developments caused or inspired by Ireland's acceptance of the European Convention and of the legal obligations which go along with that acceptance. With the aid of a small selection of cases decided by the Strasbourg Court, I wanted to bring to light advances and achievements that one can chalk up, to some degree at least, to Ireland's engagement and interaction with European human rights law. It's not an excessively difficult argument to make, and I think this is especially true of my first example, which is the case brought to Strasbourg in the 1980s by David Norris. Many of you here will be familiar with the case. It wasn't the first time an Irish citizen had brought to the international level a complaint against his or her country for a violation of human rights. Think, for example, of the case brought by Gerard Lawless in 1957 as a result of his internment in the Curragh, or the transformation of access to court in civil cases in this state and well beyond this state, for which we have to thank the redoubtable Joanna Airy from Cork, who lodged her case in Strasbourg in 1973. But Norris may well have been the case that really brought the European Court and the European Convention of Human Rights into the public eye of this country. Viewed from Ireland at that time, and I was in second BCL, 1988, I think it's correct to say that it was a ruling of very real importance, the vindication on the international judicial stage of the right to respect for a deeply intimate aspect of private life. What the applicant sought in Strasbourg, he couldn't attain through constitutional challenge. The leitmotif of the majority judgment of the Supreme Court handed down in 1983 was the Christian ethos of the Constitution. The array of arguments raised by the applicant's constitutional challenge foundered in the forecourts on that rock. In Strasbourg, the leitmotif was different, the decisive consideration being whether the restriction of the applicant's private life could be accepted as necessary in a democratic society. Norris against Ireland and the judgment which preceded it, Dudgeon against the United Kingdom, both concerned applicants from the island of Ireland subject to legislation from two different jurisdictions, which criminalised homosexual activity carried out in private amongst consenting adults. What the Norris case demonstrates is the discordance, and I should stress, in this area at that time, between the Constitution and the Convention. It also shows that Irish law at that time was out of step with the laws of most of other Council of Europe member states. In the 1980s, this meant essentially other Western European states. Ireland's response to the judgment in the Criminal Law Sexual Offences Act 1993 corrected that. While the time frame for this process can hardly be regarded as optimum, the proceedings had been instituted in the High Court in 1977, the Norris case can still be seen as something of an archetype of the Convention system. Where certain individual rights and freedoms are curtailed at the national level, they may ultimately find their vindication through the processes of the international legal order. But my purpose is not to wag a finger from Strasbourg in the present day to Ireland 40 years ago. After all, my theme this evening is modern Ireland. Let me make clear that by any standards, contemporary Ireland stands out as a society that displays the hallmarks of a democratic society as required by Strasbourg jurisprudence. If in the 1980s it needed to be beckoned by the Strasbourg court to move towards a more liberal stance in relation to some of its laws, the Ireland of now finds its place in a very different cohort of European states. It has, for example, placed itself in the vanguard when it comes to the rights and freedoms of sexual minorities. The protection which Messrs. Norris and Dudgeon sought in the 1980s is still sought in many other countries in Europe today. And here I refer to a judgment I handed down as recently as 2 weeks ago in Strasbourg in a case called Fedotova and others against Russia. The significance of the judgment lies in the clear reiteration by the court's grand chamber of 17 judges that Article 8 of the Convention requires states to provide a legal framework allowing same-sex couples to be granted adequate recognition and protection of their relationship. It's a landmark case because it comes at a time when sexual minorities are facing adversity and hostility in many European states, many of which are fellow members of the European Union. Of interest in the Fedotova judgment for present purposes is how it traces the development in the type of cases that have come before the court since the 1980s. The applicants in Norris and Dudgeon in the first wave sought above all respect for their intimate private lives. The intervening years have seen the claim for privacy evolve into applicants' claim to an equal place in society, duly recognised and respected in law. What has also evolved is the court's case law. It has never ceased to emphasise that tolerance and broad-mindedness, along with pluralism, are hallmarks of a democratic society. But it has, over time, brought other principles and values to the fore: respect for human dignity, individual freedom, respect for diversity, and inclusion. If I can quote just 2 sentences from the judgment in Fedotova, the court emphasises that a democratic society within the meaning of the Convention rejects any stigmatisation based on sexual orientation. It is built on the equal dignity of individuals and is sustained by diversity, which it perceives not as a threat, but as a source of enrichment. I think that these words speak strongly to and of the Ireland of today. The democratic choice of the Irish people in 2015 to amend the Constitution so as to make it possible for couples of the same sex to marry boosted the growing consensus across Europe. That consensus made it possible for the European Court to now develop the interpretation of the rights that are to be respected and secured for same-sex couples. As for the exact form and content of legal recognition, I should stress that this remains a matter for the states to decide. It is within the margin of appreciation of national decision makers, subject to the proviso that whatever form chosen is adequate, so that the rights conferred by Article 8 are practical and effective. That is today's European standard. Ireland surpasses it. The discordance of the past in this field, at least, has vanished. I think it's important, however, to place what I'm saying in perspective. It would be an overstatement to say or imply that the European Convention on Human Rights has been the sole or even a major driver of Ireland's transformations over the past 50 years. The character of a state is defined in a fundamental way by its fundamental law, the Constitution. Therein lies the state's constitutional identity, informing its whole body of laws, ordering its democratic life, and to some extent grounding the policy and actions of government. It's not the vocation of a human rights treaty or international human rights judges like myself to override, substitute, or compete with that. Furthermore, direct interventions from Strasbourg in relation to Ireland, by which I mean judgments finding violations of the Convention, could be described as important but episodic. By far the greater part of the developments and advances in the field of individual rights, since Ireland first joined the Council of Europe or the EU, stems from national decision-making, both political and judicial, or indeed they result directly from the free expression by the people of this island of their will. Pointing to recent judgments of note, it wasn't the court in Strasbourg, but the Irish Superior Courts, which tackled slopping out by prisoners in Mountjoy as contrary to human dignity, or the guarantees which must accompany the eviction of travellers, or the nature and extent of the right to legal assistance for those charged with a criminal offence. Yet it can't be forgotten either that in each of these cases, the Superior Courts had at their disposal a wealth of Strasbourg jurisprudence to which they could and did refer, despite rooting the legal response in each case principally in the Irish Constitution. A truer description of the contribution from Strasbourg would be to say that in some respects the court has brought oxygen to ongoing national debates, and in others it was able to address certain blind spots within the Irish legal system. Regarding the former, one can take as examples the cases concerning aspects of Ireland's laws with respect to the termination of pregnancy and reproductive rights. The first such case was Open Door and Dublin Well Woman, which was decided in 1992. The case concerned the Article 10 right to impart and receive information. The applicant organisations had been forbidden by injunction from providing information regarding the availability of abortion in the United Kingdom. Characterising the aim pursued by the injunctions as the protection of morals, and specifying that in Ireland one aspect of this was the protection of the right to life of the unborn, the proportionality of the injunctions was assessed. And in so doing, the court in Strasbourg allowed a wide margin of appreciation, which generally applies in relation to moral matters. Even allowing for this, it was the court's conclusion that the injunctions could not be regarded as proportionate restrictions on the applicant's rights. This finding rested on a series of factors, but notably on considerations pertaining to women's health and to the uneven impact of the restriction on women in different social groups. As is well known, this specific aspect was addressed by the 14th Amendment of the Constitution that same year and by legislation passed in 1995. Irish law was amended. It aligned with Convention standards. But as we know, Ireland's engagement with reproductive rights and questions relating to the termination of pregnancy has been a long, painful and winding road, and that road did repeatedly lead to Strasbourg. In A, B and C, a case decided in 2010, the Strasbourg court was confronted with profound questions about what was generally called the substantive issue, namely the interlocking legal, moral, political, medical and social issues at stake in cases concerning the termination of pregnancy. As some of you may recall, and I know the Chief Justice did because he represented the state before the Strasbourg court, the case involved 3 women in this country who had each travelled to England for an abortion. For applicant A, it was a matter of her health and well-being. For applicant B, a matter of well-being only. And for applicant C, it was out of fear that pregnancy would pose a threat to her life given a recent cancer diagnosis. All 3 applications were examined under Article 8 of the Convention, which sets out the right to respect for private life. This is a broad concept. It encompasses matters such as personal autonomy and development and one's physical and psychological integrity. In the case of A and B, who it was completely clear could not have obtained a lawful abortion in Ireland, given the basis on which they sought it, the court had to examine the balance achieved under Irish law as it then stood, the 8th, 13th and 14th Amendments to the Constitution. The balance was between, on the one hand, a public interest described as the profound moral values of the Irish people as to the nature of life, and consequently as to the need to protect the life of the unborn, and on the other, the important personal rights of A and B. Recognising the acute sensitivity of the moral and ethical issues at stake and the importance of the public interest, a wide margin of appreciation was again allowed for the state in deciding where the fair balance was to be struck. Yet, however wide, a margin is still a margin. It has an outer perimeter, and that outer perimeter is under the supervisory jurisdiction of the Strasbourg Court. The public interest may be of very great weight, but it must still stand in a relationship of proportionality to the right of the individual that has suffered interference. The approach taken by the court was finely calibrated, with due regard to the choice that had emerged from the lengthy, sensitive, and complex debate in this country. Setting the possibilities and supports that were available to A and B in Ireland against the undoubted burden that travelling to England meant for them, the judgment concluded by rejecting their complaints. Regarding C, the analysis was different, as was the outcome. C's case raised the question of the application in practice of the interpretation of Article 40, paragraph 3, subsection 3 of the Constitution in the X case, handed down by the Supreme Court 18 years previously. The complaint was of a failure by the state to act, a failure to put in place effective and accessible procedures so that a woman and her doctors could establish whether or not she had a right to a lawful termination of pregnancy in Ireland in view of her personal situation. This lack had already been pointed out by the Irish courts, trenchantly by Mr. Justice McCarthy in the X case, but also in the various sets of discussions that took place in the latter part of the 1990s and the early noughties. The tragic effect of the no person's land in which women, their next of kin, medical staff, the courts, and the unborn was left is particularly well illustrated in the case of PP against the Health Service Executive from 2014. The Strasbourg Court in the C case referred to a striking discordance between a right of access to medical termination of pregnancy that was recognised in theory, one that sat within the very terms of the Eighth Amendment, but its practical implementation or lack thereof. On this basis, the state's obligation towards C was found not to have been fulfilled. If I've taken some time over this judgment, the content and reasoning of the court, it's because it illustrates so well the point I wish to make about the nature and degree of intervention from Strasbourg on a question of exceptional sensitivity that was the subject of a long and difficult conversation in this country, taken in stages decade by decade. The result of the ruling on C's complaint was the regulation of access to abortion in line with the X judgment in the form of the Protection of Life During Pregnancy Act 2013, over 20 years after the Supreme Court had ruled in the X case. Things might have stayed as they were after this, once compliance with the European Convention had been achieved. But the societal conversation, to which I think it is fair to say the Strasbourg Court brought a degree of oxygen, had not yet run its course. Most properly, the ultimate word was reserved to the ultimate source of political power and legitimacy, to the people in their role as constitutional lawmaker. In 2018, following an innovative process of debate and deliberation in the Citizens' Assembly, and then consideration in the Oireachtas, the people of Ireland revised the settlement with respect to personal rights in Article 40 of the Constitution. The other phrase I use to describe the function of the Strasbourg Court is that it provided an opportunity to address national blind spots. As an example of this, one can take the judgment delivered in 2002 in a case called DG against Ireland. The applicant was a young man who, while still a minor, had been placed by the High Court in St. Patrick's Institution for a month in 1997. This had been done with great reluctance as the least worst option available at a time for a young person from a very troubled background who posed a real danger to himself and to others. His needs in terms of care, treatment and education were such that they couldn't at that time be met by the state, there being no suitable secure unit available. The discomfort, indeed the dismay of the High Court at the absence of any adequate solution and the necessity of putting one together by judicial fiat comes through very clearly in its judgment. Bringing his case to Strasbourg, the applicant complained in particular that the circumstances in which he had been detained disclosed a violation of his right to liberty under Article 5. This provision safeguards a core human right, and so the various grounds on which it permits the restriction of liberty have to be interpreted narrowly and strictly. The court held that the applicant's detention in a penal institution, subject to its disciplinary regime, could not be equated to the detention of a minor for the purposes of educational supervision as claimed by the state. It was thus an unjustified restriction of his liberty, a violation of the Convention. It followed from this finding that the state would have to address the underlying problems of structure and resources brought to the light by the applicant and by the judgment of the Strasbourg Court. This wasn't a task accomplished overnight. As the government later reported to the Committee of Ministers, through the passage of the Children Act 2001 and later the Childcare Amendment Act from 2011, an appropriate statutory framework was brought in to regulate the placement of minors in secure special unions. In this way, and not without considerable difficulty, this particular blind spot was corrected. Before I move on from remarks that concern specifically the effects on and in Ireland of cases decided by the Strasbourg Court, I'd like to make the point that one of the themes running through this quantitatively modest body of case law is the demand of individual applicants or members of particular social groups to be seen, to be heard, to be accepted, to be included, to be taken into account as much as any other member of society or any other social group. It's there very clearly in the Norris case. It's there in the famous Airy case. It's there in the Johnston case from 1988, in which an unmarried couple unsuccessfully challenged the lack of divorce in Ireland. They succeeded, however, in their complaint regarding their daughter, who, as a result of her parents being unmarried, was placed in an inferior, inadequate legal situation that failed to respect their family life. The solution was the Status of Children Act 1987, bringing equal treatment concerning guardianship, maintenance and property rights. A similar demand to be seen, heard, accepted and included is also evident in the Keegan case from 1994, where the applicant complained of the lack of consideration in Irish law for natural fathers. His infant daughter had been placed for adoption without his knowledge or consent. Sometimes the Strasbourg Court pushes. The open door case is a good example. Sometimes it has to shove. The case of Louise O'Keefe and historical child sex abuse in primary schools is a case in point, although I should add that some argue that the right result was achieved in a case where admissibility conditions were nevertheless short-circuited, the Supreme Court never having been seized of the legal complaint that the Strasbourg Court ruled on and the material which succeeded in Strasbourg. But in many other cases, the Strasbourg Court has successfully nudged states into recognising and rectifying their blind spots. This method works when the respondent state accepts that under the Convention, it is the state and not the court in Strasbourg which bears primary responsibility for assuring respect for Convention rights and freedoms. Furthermore, it is a responsibility which finds expression in the obligation to which the states voluntarily have subscribed under international law. Having concentrated so far on Ireland, I'd now like to change the focus from the geographic to the thematic. As I said in the exchanges I had with the department about the content of the lecture, there was an idea inspired by the figure who we celebrate today of taking up a theme of particular relevance to women, to the protection of their rights, and to the goal of realising gender equality. There's no doubt that the European Convention, interpreted by the Court as a living instrument, is of great significance here, as demonstrated, I think, by some of the cases that I've just referred to. However, in a series celebrating EU50, to give a full account of European legal achievements in this field, of equal treatment and equal opportunities, one should speak as well, and perhaps at greater length, of what has been achieved by the European Union through its laws, policies and actions. Mention would then be made of the extremely important contribution of the rulings of the Court of Justice of the European Union in Luxembourg on such staples as equal pay, equality in professional or occupational life, equality in the broad field of social security, and so forth. Who here knows the names of Nora McDermott, Anne Cotter, Mary Murphy, Nora McDermott and Anne Cotter for a second time, Teresa Emmett, Kathleen Hill, Anne Stapleton? We should know their names, because the rights that we enjoy, they vindicated for us before the Luxembourg Court. These cases, the early wave of which were brought to the Luxembourg Court by the same champion which the Minister mentioned, our first president, female president, Mary Robinson, achieved very concrete benefits for women in the workplace, and therefore for men and society too. My remarks this evening cannot extend that wide. What I will dwell on is illustrative of the Strasbourg Court's continued and important role. It's the steady development of a body of case law on domestic violence, also mentioned by the Minister. Cases brought by those who have endured and survived it, and cases brought, sadly, by their next of kin. These cases are not a cause for celebration. It's a fundamental human right for everyone to live a life free of violence in the public or private sphere. The cases I'll refer to underline that the goal of gender equality is far from achieved when national authorities across Council of Europe member states are repeatedly in the dock for their failure to protect the rights of victims, more often than not women and children. From the 2009 landmark Opus against Turkey ruling onwards, a succession of domestic violence cases has seen the European Court approach the issue from the angle of several substantive provisions of the Convention, mainly the right to life under Article 2, the prohibition on severe ill treatment under Article 3, the right to protection of one's physical and psychological integrity, Article 8, and the prohibition of discrimination. In 2021, in a case called Kurt against Austria, the Grand Chamber of 17 judges adopted a judgment which marked a step forward in the perception of and response to domestic violence from the standpoint of the Convention. The facts of the case are as tragic as they are recurrent in this field. Pattern of escalating violence directed first at the applicant mother and which culminated in a murder-suicide, with the applicant's 8-year-old son fatally injured by the father at his school. The emphasis throughout the judgment is on the need for national authorities to take due account of the particular context and dynamics and the known specific features of domestic violence. What also marks this case out is the degree to which the court drew upon specialist international instruments, such as the Istanbul Convention mentioned by the Minister, and the expertise made available to the court, both by intervening parties and by, above all, the expert body that monitors the implementation of the Istanbul Convention, Grevio, who, as you've heard, is visiting Ireland this week. In this case, rarely has the permeability of the Convention to other human rights treaties been so clear. The result of the Kirk case is the adaptation of the qualified duty that the court has derived from Article 2 for states to take adequate operational measures to protect an individual from a real and immediate risk to their life. These are very difficult cases because the violence builds up and manifests itself in the private sphere, and the legal burden placed on the state cannot be such that it is unworkable. In relation to most convention rights and freedoms, it becomes apparent relatively quickly as a judge at the Strasbourg Court where the blind spots and systemic weaknesses of the 46 Council of Europe states reside. I focused on domestic violence because it is an all too common scourge encountered in all European states. For a 6-month period in 2022, as the Minister explained, Ireland led the Council of Europe as President of the Committee of Ministers, displaying energy, engagement and enthusiasm at all levels of government and in the relevant departments, led by the department in which we sit this evening. Of several achievements, I think it is worth singling out the Dublin Declaration on preventing domestic, sexual and gender-based violence, which was championed by the Minister for Justice and which was adopted last September. This is how international standards are upheld and taken forward by internationally minded states. The declaration and the work behind it speaks to the important role which states like Ireland can play in multilateral organisations. 50 and 70 years down our European road, we reflect upon and engage critically, but in a constructive manner, with what membership of the Council of Europe and the European Union has meant to us in this state. Ireland has shown, I think we can say, great aptitude in influencing well beyond its economic and democratic heft the course of European integration, and long may that continue. I started with a personal note and I will end with the same. In 2019, I was asked by the Irish Embassy in Strasbourg to open an exhibition to celebrate the lives and legacies of 19th and 20th century Irish women who had made lasting contributions in Europe and beyond in their very different fields. Women like Fanny Isabel Parnell, born in 1848 into a country ravaged by famine, who campaigned for famine relief, social justice, and Irish nationalism when she moved to the United States. She wrote poetry and is lauded for having written the Marseillaise of the Irish peasant. She also volunteered for the American ambulance during the Franco-Prussian War. Or Iveagh Booth, the trade unionist and suffragette, who went on to campaign for the abolition of capital punishment. She did this in 1914. Protocol 13 to our convention, providing for abolition of the death penalty, only entered into force in 2003. Looking out at the Irish European audience that day in Strasbourg, I saw my own lived experiences in the faces of many of the Irish women present. The women we had gathered to celebrate were trailblazers and well deserving of our public commemoration. But we had all been brought up by quiet trailblazers, grandmothers, mothers, fathers, teachers, nuns, who had understood that they were shaping women to inhabit a future, modern and European Ireland. And on the 1st of February each year, it is to the memory of those quiet trailblazers that my thoughts turn. Thank you very much for your attention.
Thank you very much for that, Judge O'Leary. That was absolutely stunning. So I really appreciate it. I'd like to also welcome to the panel Senator Fiona O'Loughlin, head of Ireland's 8-person delegation to the Council of Europe Parliamentary Assembly and chair of the Oireachtas Women's Caucus, and newly and unanimously elected president of the European Committee of Social Rights, Professor Aoife Nolan. You're very welcome. Síofra, that was an amazing speech, so thank you so much for that. You know, you mentioned a few times about the wide margin of appreciation that member states have in order to keep everyone on board, particularly on moral issues or social issues. But with that, obviously, taking that, I suppose, into account, there's still, it appears, a disregard from some member states for the rights of minorities when it comes to things like gay rights, LGBT rights. Is that something that you're actually seeing, or is that something that we believe is actually happening?
I think the serving judges here present will understand that I will have to skirt around some of your questions because we have many pending cases relating to that very issue. I refer to the Fedotova case against the Russian Federation because it shows clearly from the highest judicial formation of the court what the standard is under Article 8 in 2023. It is equal respect for same-sex couples and recognition in law, some form of legal recognition. But we have cases pending in relation to Poland, in relation to Latvia, Lithuania, etc. As I said, many of these states are also fellow members of the European Union. So these cases go not just to the Strasbourg court, but also to the Luxembourg court.
Obviously, you have a bit of a challenge on your hand. We saw Russia leaving the Council of Europe, which is obviously quite unsurprising, but disappointing nonetheless. What happens to those thousands of cases still pending when it comes to Russia? And do you think it would have wider implications, one country leaving?
I should rectify one thing. They didn't leave, they were expelled.
Oh, yes, expelled. Sorry, yeah.
But there is an important distinction. I mean, the timeline, you all know it. There was an invasion on the 24th of February. The pace met very quickly, and the Committee of Ministers of the Council of Europe decided to expel the Russian Federation from the Council of Europe. What followed were decisions by the court as regards the legal consequences of this in relation to the Russian Federation and the Convention. And the court in its plenary, that means all 46 remaining judges, confirmed that the court retained residual jurisdiction. Essentially, we will continue to examine Russian cases as long as the acts or omissions which lie behind the alleged violations of the Convention took place before the 16th of September 2022. Why that date? Because on that date, according to Article 58 of the Convention, Russia ceased to be a high contracting party. We have 16,700 pending Russian cases. We have 8 pending interstate cases involving the Russian Federation. In all but one of those cases, they are the respondent state. What does this mean? Well, we continue to deal with the cases, but we have worked out a system by which we will deal with them. The most difficult questions will go to the Grand Chamber, but we've dealt with the 2 remaining ones. Chambers of 7 judges will continue to deal with cases which are of particular importance in relation to civil society activists, freedom of expression, freedom of assembly, the rights and freedoms which relate to democratic good governance, essentially. there are many, many repetitive applications against the Russian Federation. For example, conditions of detention in penal institutions in Russia. 11,000 of these 16,000 cases are repetitive cases. We'll deal with them in a much more simplified manner by committees of 3 judges, and we have very effective and efficient tools developed because sadly the Strasbourg court has always had thousands and thousands of cases on its docket.
I suppose closer to home, and certainly not a country that's being expelled, but there are concerns about the UK's relationship with the court, even though obviously the UK was one of the states responsible for drafting the convention. What implications do you think that would have for Ireland? Well, obviously we know that in relation to the Good Friday Agreement, it would be quite catastrophic.
I don't think I can engage with whether or not the United Kingdom is considering leaving the convention.
Yeah.
What I can report is that the Deputy Prime Minister visited Strasbourg in January. He confirmed his commitment to being a Council of Europe member state. He confirmed his commitment to the convention. We had a very open and cordial exchange. He explained his Bill of Rights. I explained that as a president of a court, and certainly an international court, I don't engage with governmental policy or legislative proposals. Again, I think the sitting judges will fully support me and understand me in that regard. And I was able to explain that the facts and the evidence that we have in Strasbourg, the United Kingdom has the lowest number of applications calculated per 10,000 inhabitants. We have a particular figure we use. For the UK, it's 0.03. The convention average is 0.53. Ireland is 0.07, by the way. That's quite good news. Germany and Ireland are the next closest to the UK. That means in concrete terms that in 2022, we had 260 applications from the UK. 256 of them, I think, more or less, I think my figures are right, were struck out or deemed inadmissible. There was only 1 violation found in 2 cases relating to 3 applications. Judges deal with facts. So I provide the facts when asked a question like that. What I can't do is engage with legislative proposals, particularly in relation to another state and particularly as an international judge.
And I suppose just final question, I mean, just on the Good Friday Agreement, I suppose just the influence of the convention on that very important agreement.
I think there are probably experts in the room who know more about this than I do. We know that the convention via the Human Rights Act is a very important part of the constitutional settlement in the United Kingdom in relation to Northern Ireland. I don't think you need to hear me on this subject. There's been excellent evidence provided by Queen's University Belfast and others to what was called the Gross Inquiry, which was an inquiry into whether or not the Human Rights Act should be maintained. We know that following the Good Friday Agreement, the Human Rights Act was a very important part of it, but also that the adoption of the European Convention on Human Rights Act in this jurisdiction was a necessary riposte to the Human Rights Act and the Convention applying, the idea being that there would be equal access and protection of human rights throughout the island of Ireland.
Thank you very much. Professor Nolan, and congratulations on your appointment this week. Talk us through, I suppose, your priorities, as president of the committee.
Absolutely. Well, I'm conscious that while everyone in the room here is going to know what the European Convention is, there are probably going to be significantly fewer that are familiar with the system I'm involved in, which is the European Social Charter. And it's often said that the Social Charter is a sister instrument to the European Convention. But I think it's probably fair to say that it's kind of the distant cousin that isn't really often invited to family weddings, if you think about its overall profile. So obviously a key priority as president is to drive forward awareness of and the profile of the Charter and its rights at the national and the international level, because and part of it is that the convention has the court and it's an associated body with the social charter. Our treaty looks at things like the right to social security and social and medical assistance, the right to housing, very extensive labour rights, including for women, given the day that's in it. But we don't have a court. What we have is we have the committee, and what we do is we monitor state efforts to give effect to the charter by looking at state reports. So very much what happens with UN treaty bodies, and we make findings of conformity and non-conformity. So for instance, in about 2 weeks' time, maybe 4 weeks' time, depending on when the translation is done, we will be issuing our conclusions on state reports last year, where we look at labour rights and a whole range of different issues. In addition to that, we also have a collective complaint system, and Síofra has spoken very effectively, I think, about the power of the individual complaint system of the court. We, on the other hand, have a system that involves cases being brought to address structural and systemic issues brought by certain NGOs, trade unions, employers' organisations and other social partners. So it's very different in nature. We're not focused on providing individual remedies. We look at national situations and wide-ranging and the impact of wide-ranging legislative and policy frameworks on particular groups of right holders. And one of the crucial differences, I think, just to flag in terms of our profile and part of the challenges around it, is that with the convention, obviously, to paraphrase the minister, it's both a legal obligation and a moral imperative to follow the outputs, the judgments of the court. With us, our outputs are there is no equivalent obligation. We have no equivalent of Article 46 of the European Convention. So the requirement is, when states sign up to these treaties or volunteer to be bound by them, that they must in good faith, they're expected in good faith effectively to go along with what the outputs of the treaty monitoring bodies of those systems are, right? But to be clear, as such, it is a moral imperative, but it's not a legal obligation in the sense that you have with the outputs of the European Court. And that, of course, in turn, makes it challenging to get as much attention from national systems as you will, where a decision immediately has an impact on that national system.
And one of the areas that you're covering quite a bit is the rights of children, the rights of the child. And we've seen a huge increase in children falling below the poverty line. Talk us through some of your priorities around that.
So as a committee, we have, in contrast to the convention, we have a very wide-ranging provisions setting out the rights of children to things such as education, to care and assistance, to protection from violence. And we've used that as a committee. We have a whole series of standards, of guidance, and also decisions focusing in on different aspects of children's lives. So I think as we look at this situation in the context of the cost of living crisis or polycrisis, because of course it's following on and linked to the Ukraine, and it's following on and linked to the COVID pandemic, it'll be very much about taking those standards and trying to provide guidance to states about how charter rights can be used as a framework for state responses in such a way as to ensure that states' responses give effect to children's rights, that they prioritise children and other vulnerable groups in, say, their legislative, their policy making, their budget decision making in response to crises. So I'd say for the next couple of years, that will be a key priority for us as a committee.
And alongside that, we've seen a huge increase in the number of unaccompanied children, particularly coming from Ukraine, but before that, Syria as well.
Absolutely. And I think if you look at our jurisprudence, there's a huge, very significant amount of cases around issues such as the rights of unaccompanied children arriving in Greece, housing rights and other rights. We have very extensive jurisprudence as well around Roma children and other vulnerable groups of children that we can leverage, I think, to really push forward and address this, the issues of inequality and poverty faced by children across Europe over the coming years.
And alongside the crisis that we're facing at the moment, the cost of living, is labour rights. I mean, there seems to be a labour shortage, but at the same time, an exploitation of workers, where workers are working, but they can't seem to pay bills and so on. I mean, how can you focus on that to ensure that there's some sort of levelling out, particularly when you look at sort of new areas like platform workers and so on?
So I have to be a little bit, like Síofra, I have to be a little bit careful because our conclusions that will be coming out in a few weeks very much focus in on the issue, a series of labour rights issues. And one of the things we look at is minimum wage, and the minimum wage being of an adequate standard to ensure, a reasonable standard of living. And some of the challenges we faced in the last few years have been taking traditional labour rights or work rights standards and applying them to, say, platform workers or workers that are quite different to those who are doing work in a way that is quite different to what we've seen, what was conceptualised, say, when the charter was drafted. So that has been a very heavy focus of ours. And I, for instance, about 2 years ago, we provided guidance to states and what we call statements of interpretation on highlighting that states must ensure that platform workers are covered by social protection. We will be, in our conclusions that are coming forward in the next few weeks, we'll be talking about platform workers and the minimum wage. How do you manage that situation? So it's about, I mean, very much in the same way that the court and the convention has, the court has had to take the convention and apply it to situations that were very much not envisaged at the time of the adoption of the convention. We have to do the same thing with the charter. And as you flagged there, Fiona, given the particular shifts that we've seen around, changes to work conditions and the nature of work, that is a real challenge, and it's one we're engaging with very seriously.
Senator O'Loughlin, you're chair of the Oireachtas Women's Caucus. I suppose just after what we heard from Judge Síofra O'Leary there, how has EU membership and also member of the Council of Europe shaped women's rights in Ireland?
In a huge way. And firstly, can I say, sharing the platform with two esteemed ladies such as President O'Leary and Professor Nolan is a little bit like being at the Oscars for me. In terms of Oscars were being handed out in terms of human rights, that both ladies would absolutely be up there at the top. But in terms of changing rights around women's right to work, absolutely, as President O'Leary outlined. When we look back in history, the first women who entered public service as such was around the year 1870, and they were able to enter the post office network to work within post offices. And that was, seen as a trial at that time. And 20 years later, another trial was put in place in terms of opening civil service jobs to women. So women then had a foothold. Obviously, they would have been involved prior to that in private industries, such as, private shops, private farms, etc. And when we look at 1835, shall we say, there was quite a number of women working, but the marriage bar was brought in 1935. 1936, the marriage bar was brought in. And that was a huge obstacle for women who had to resign their jobs when they married. And it's incredible to think that it actually lasted for so long. And it was only in the 1970s that the marriage bar was done away with. So in actual fact, and that was because of Europe, that was because of European decisions, and Ireland haven't complied with that. And in fact, in 1978, there was a smaller percentage of women working because of that. It had gone down to about 23%, where it had been 31% in 1936. So that really shows the difference that had happened because of women not being allowed to work. So, of course, when the marriage bar then, firstly, it was taken from public service, and then legislation was brought in to ensure that private companies followed through. But then automatically, childcare and different areas had to be legislated for to enable women to work. Now, obviously, we know it's taken a long time to catch up, and we're nearly only catching up now in terms of being able to support working families in terms of childcare. So most certainly that made a huge, huge difference.
And it still does, of course. I mean, we're still looking to Europe, or do you feel that Ireland is more leading? I mean, you're saying sort of catching up, but how would you say that Ireland, from a parliamentary perspective, ranks across Europe?
In many ways, we rank quite well, but I think in terms of childcare, we have not been good. When we compare ourselves to some of the Scandinavian countries and to Iceland, the fact that they have free childcare, the Prime Minister herself would put that down to the fact there's so many women in politics, because they have free childcare. So women were freed of the burden, if I put it like that, of childcare, but then obviously had the opportunity to spend time with their children after that. And I was in France yesterday, one meeting that we had, and it was in relation to monitoring France around the areas of human rights and democracy. But the Minister for European Affairs said, and I thought it was an interesting point, the fact that in France, the school runs until 6 o'clock in the evening, which is quite late, but it means that working women didn't have to have that balance of trying to collect children from school at 3 o'clock and try to do homework with them, either then or in the evening time. So that really gives an opportunity. So I think that we do have a lot to learn. And in terms of where the next big area, that Ireland has to really look at it, and we are looking at it in terms of the Constitution in relation to 41.2, the whole area of care, because generally speaking, women have childcare, care of maybe elderly parents, siblings, and particularly during COVID, we saw that, if I may call it a burden, rested with women. So I think that the Citizens' Assembly has done really excellent work in relation to that, and I understand that the wording by the Oireachtas Committee that have been commissioned to do this under the chairmanship of Deputy Ivana Bacik will have that wording quite soon. So I think that's a really important area for everybody, but particularly for women.
Is there a serious conversation, though, in the Oireachtas about, making things more child-friendly, or at least women-friendly in the Dáil? Because you hear about politicians not being able to stay late at night for voting, for example. Also, coming up to Dublin so frequently is a bit of a problem. Is there a proper conversation about how to make it a little bit easier?
Through the work of the Women's Caucus, we certainly have been trying to push for much needed change. And Minister Burke mentioned about the maternity leave for councillors. And we have been working with Minister O'Gorman in relation to maternity leave for Oireachtas members also. And obviously the courageous decision that Minister McEntee did really pushed that on the agenda. We also have been working in a family-friendly forum that the Count Corla put together with women from inside the Oireachtas and outside the Oireachtas, and including staff members, because a lot of staff members have to work really late and have to work later even than the elected members in terms of making sure that bills are ready for the following day with amendments, etc. They can be working right up to midnight and beyond if there are late sittings. So we have come up with a number of recommendations around having family-friendly rooms, for example, so that in the case that you mentioned, Fiona, where members may have to come up from the country, if they have the opportunity of bringing maybe small babies or toddlers with them, and if they have a break during the day, that they don't have to leave the vicinity of Leinster House, that there would be a place where they could go and meet their child with a family member, for example. You talk about the late voting hours. Absolutely. One of the recommendations we made was that there would be no votes after 9 o'clock in the evening, which is still relatively late. There is an issue with the Oireachtas creche, which is there for everybody who works within the vicinity of Leinster House, including staff and including press. And they have to still collect their children by 6 in the evening, which really doesn't support the late working hours. And also there isn't a situation where, for example, a senator or a deputy would like to bring their child maybe for 3 days. They can't do that. You have to subscribe to 5 days. So obviously you're not going to subscribe to 5 days, pay for that and only use for 3. So there's a lot of different measures like that that we still need to continue to work on.
Justice O'Leary, you were talking about how the membership of the Council of Europe and the EU has shaped rights for women. Is that an area you'd see has influenced Ireland the most when it comes to women's rights or access to various rights for women? Is it the biggest influence?
I think one of the reasons why I cast my net wider was because I thought it was quite reductive of the role of the convention just to focus on women's rights, and also because EU law has done so much in relation to where you empower women, which is by giving them equal rights in the workplace. That doesn't mean that everyone has to work, but rather that you have an equal right of access, equal opportunities once you're there. It gives women control over their own lives and therefore empowers them in society generally. So I didn't want to either focus the convention contribution only on women's rights, because on discrimination issues, the convention is a little bit shakier than EU law is. But also I think in terms of the development of Irish society, casting the net wider was very important because there are other social groups.
Indeed.
All a question of gender.
Aoife, you're nodding your head there.
No, I would very much agree with Síofra's analysis there. I suppose I was also thinking that, when the court is dealing with this, often it's through the frame of non-discrimination, Whereas when we're dealing with it through the Charter, we have the benefit of explicit provisions that talk about the right to, equal work for equal pay, and talk about the need for protection of, there's an explicit right to protection of workers with family responsibilities, and right to protection of women in the context of maternity. So it's, in some ways, it's an easier exercise for us to engage with it conceptually in our work than it might be for the court, having to use, say, Article 14 and a non-discrimination framing a lot of the time.
Fiona, do you think the rights that do exist are applied properly? I suppose maybe in your own career path, but also elsewhere across Ireland.
I think that they have to be monitored to ensure that they do, and that's an area that Council Fiona is really good on in terms of monitoring countries and their obligations in relation to democracy, human rights, and the rule of law. And there are countries that have that annual monitoring, particularly in relation to the area as was mentioned before, in relation to, for example, the Istanbul Convention and gender-based violence. And then there are periodic reviews with some of the larger countries. So I think while it's so important that they are there, having a constant monitoring, and that's where I think the parliamentary assembly is really good too, because when you're working together with people that are elected right across Europe, you do have the opportunity to influence, I think, both within committee work and in terms of getting people to live up to the standards that are there. But without the monitoring mechanism, and I do believe that there possibly should be sanctions brought in relation to where the countries that have signed up actually haven't really been living up to that. It's interesting, and the point was made by Síofra earlier that Ukraine signed up to the Istanbul Convention about 6 months ago. The UK only signed up at the same time, and about 2 months before that, Turkey pulled out of it. Even though that convention was negotiated. So that's a concern, and the backsliding of democracy in general is a really big concern, and that's why one of the recommendations that we have made in her report for the Focus Summit is that Commissioner for Democracy and the Rule of Law be established to ensure that we try to stop that backsliding that we are seeing in countries, unfortunately, in relation to LGBT rights and gender-based violence.
Are you able to speak to that? I mean, just the concerns, Síofra, just in relation to concerns about backsliding and, signing up to conventions and yet not adhering to them, and it just being, lip service, essentially.
It's why we have 75,000 pending cases. It's why we have 75,000 pending cases. Each country's problems, weaknesses, weak spots, as I said, are different. But what you can see across the board is rule of law, democratic backsliding, attacks on the independence of the judiciary, muzzling of the press, restrictions on the rights of civil society activists. In some countries, it's very extreme. A very good example is a judgment we handed down last year, again, in relation to the Russian Federation, a case called Echo Defense. This was about essentially shutting down the independent organizations which existed in society and which reported human rights abuses and democratic backsliding. Memorial, one of the applicants, was one of the winners of the Nobel Peace Prize in 2022. So yes, that is why there are so many applications. It's also why there is a high percentage of judgments of the European Court of Human Rights which are not executed. That relates also to many different states, not just the usual suspects. I am, of course, asked, but is it worth, therefore, the paper it's written on? I think the answer to that is yes. It's even more valuable now than it has been for several decades. We perhaps grew a little bit complacent about the societies that we live in, the freedoms that we have. They can disappear very quickly. And just look around Europe. And again, I'm not talking just about the usual suspects. We have experienced a time of peace, stability, and prosperity like no other in the history of this nation. Things can change quite quickly. So the commissioner that I saw referred to in Fiona Loughlin's report is something which speaks to the times in which that we're living in. The idea of appointing a democracy commissioner.
I mean, are you just sort of hopeful that we'll get to a better place? That you'll have eventually governments in place who feel the need to adhere to the judgments. Or is there a greater solution that you could think of that eventually means that people are actually forced to adhere to these judgments?
The convention was described by one of my predecessors, Lucius Wilkhaver, as a project of idealistic realism. You can't do this job without being somebody who is an idealistic realist. Many states comply with their obligations. They execute the judgments. They support the court. They are monitored and change legislation. All of the cases that I referred to today led to changes in legislation, led to the transformation of some people's rights and indeed some people's lives. It does take time. But if we've learned something in 2022, it's that this is a project based on common shared values, which is definitely worth fighting for.
Yes, I think I will leave it at that optimistic note anyway. So thank you very much, Aoife Nolan, Síofra O'Leary and Fiona O'Loughlin. And now, thank you very much for that again. I'd like to introduce our acclaimed harpist and Shan Nose singer, Sheila Denver, and fiddle player, Valerie Casey.
Banachtaí na féile bríde or fad se go hálan a bheith seo in Dheonach Libanacht. We're delighted to be here, myself and Valerie, to celebrate Láile Bríde or Imbolg with you all. We're going to do two short pieces for you, a song and a set of tunes. And we'll start with a song called Shohisteach Ma Brídóg, a song that I wrote myself. I was delighted last year to be commissioned by the Department of Foreign Affairs and the Irish Traditional Music Archive to write a piece to celebrate Brides or Brigid. So myself and two of my musical friends, Patsy Nagown and Louise Mulcahy, who you saw in the film there a while ago, we spent a lovely few days just around the corner in Merrion Square in the Irish Traditional Music Archive, researching traditions around Brides, and we put three creative pieces together. So I chose to base my own piece on traditional rhymes from Connemara in the west of Ireland and County Galway, which is where I'm from. And the first verse of the song refers to the Brídóg, a small doll or an effigy of Brides that young people would have made, and they would have gone around to the houses with the doll asking for a penny for Brides, and that it would be good luck for the people in the house to give the penny. And then the second verse is about an Chis Bríde, which is the belt of Brides, and it was a large circle made of straw that was woven again by usually the young people with 4 crosses on it, and they used to go from house to house and say this rhyme, Shohisteach ma Chris, here comes the Chris na gera gros, the belt of the 4, the Chris of the 4 crosses. Shastar tatu nacht gum shach mi de fer avestu blian on nacht. As well as you are tonight, may you be 7,000 times better this time next year. So it's lovely that a lot of our traditions are going to be celebrated again now for Láile Bríde, and these traditions gave people a lot of meaning, and I think they still will and still do. So this is Shohisteach Ma Brídóg, and I'm delighted that Valerie's joining me, and we're going to play a set of tunes after that, which finishes with the woman of the house, appropriately for the night that's in it. So go to Mina Mahagi. Shoishtach mobidog chonati. Naira vanati, I see glaze the chonati. Shoishtach mobidog is a beishi buiri. Shoishtach mobidog chonati. Shoishtach mochiris, o Chris negere gros. Naida vanancies, take the free to get is. Masara tosha bennacht, Gamashach the meal I bet you piano, Shawshank kiss and get a garage. Okay.
You have been disconnected.